Good afternoon, everyone. I'm Tonia Nunez. I'm the Director of Metro Volunteer Lawyers, and we are so excited today to bring you DV in DR. We are thrilled to have our two speakers here, that Jennifer and Amy. They are really and truly champions in this area, really advocating and protecting people when they need it the most. So I'm going to go ahead and do a little bit of housekeeping for you. First of all, please, as I said, make sure that you're muted as you come in, and you feel free to turn your camera on or off. We are recording this and we'll be putting it up on our website after. In addition, all the materials will be sent to you after the CLE is completed, including your affidavit. We can't do this without our volunteers, so I wanted to give a shout out to say, could you kindly think about going to our website? It's www.denbar.org/MVL, and look to volunteer with us. We do all sorts of work, a lot in the domestic arena, and we actually are really excited that we have our own fellow this year that only helps with victims of domestic violence, Becky, and we'll meet her in a second. So thank you for joining us. As I said, we'll get going and we'll send all the stuff to you. If you have questions during the presentation, please put them in the chat box, and I will make sure that we reach out to the speakers and let them know what your questions might be. So again, thank you so much, Jennifer and Amy, for joining us and leading us in this wonderful discussion, and I will hand it over to Becky.
Hello, everyone. My name is Becky Dumbleton, and as Tony Ann said, I'm the Colorado Civil Justice Corps Fellow at Metro Volunteer Lawyers. My position is funded by the Victims of Crime Act, and I represent victims of domestic violence through MVL's various family law programs. I'm here to introduce our two speakers today, Jennifer Isle and Amy Pohl. Jennifer and Amy have both worked in direct victim services and in educational roles, teaching various professional groups about domestic violence and related topics. Jennifer has been working in the field of domestic violence since 1994. She has worked at Rocky Mountain Children's Law Center, was a child and family investigator, and is now the executive director at Project Safeguard. Jennifer is known statewide for her expertise in domestic and sexual violence. Amy has over a decade of experience working in the domestic violence field. She has worked at the Wyoming Coalition Against Domestic Violence and Sexual Assault, the Center for Relationship Abuse Awareness in Palo Alto, California, Violence Free Colorado, and is now a senior staff attorney at Project Safeguard. Today, Jennifer and Amy will be discussing domestic violence in domestic relations cases, what it is, why it's important, and how to address it. If you have any questions, feel free to put them in the chat at any point during the presentation and we'll get them answered for you. Please join me in welcoming Jennifer and Amy.
Before we go straight to Amy, I did want to do a shout out. Project Safeguard just does such wonderful work. Please make sure that if you'd like to volunteer as a contract attorney with them, that you do reach out to Jennifer, and we'll make sure that her email and information is also in the chat. Thank you.
Thank you so much, Tony Ann. And I will just briefly explain to everybody what Project Safeguard is for folks who aren't familiar with us. Project Safeguard is a community-based nonprofit located in Denver that serves Adams, Broomfield, Arapahoe, and Denver. And we serve victims of gender-based violence. So that's domestic violence, sexual assault, and stalking, as well as human trafficking. We have legal advocates who are non-attorneys who work with survivors on civil legal issues related to their victimization. And we have 4 full-time attorneys currently on our staff, not including me, who are providing direct civil legal services to our clients. We have a divorce and custody clinic where we utilize volunteer attorneys to help our clients get the process of filing a divorce or an allocation of parental responsibilities case started. We have our Lawyers for Victims program, which is a contract attorneys program where attorneys contract with us to represent clients in their civil protection order cases in county court. And as Tony Ann said, if you're interested in working with us in any of those capacities, please feel free to reach out to me. My contact information is at the end of our presentation. So let's go ahead and take a look at what our training objectives are for today. We want you to leave here today with these 3 primary understandings. First, why is it important to understand domestic violence in domestic relations cases, how to recognize and respond to domestic violence when it is an issue in a case, and how to draft, negotiate, and argue for appropriate separation agreements and parenting plans on behalf of victims of domestic violence. And I just want to say, as Amy and I were putting this presentation together, we sort of said, gee, we could do a whole day on a variety of these topics that we're just going to touch on. So as we go through, we are going to move fairly quickly. We are going to cover a lot of information. And if there are things that you notice that you'd really like to know more about, if you would maybe note those in the chat or let Tony Ann know that, then maybe we can look at doing something a little more focused on a specific topic in the future. Amy, go ahead.
Thanks, Jen, and thanks everybody for joining us today, especially as I'm sure some of you were on the Family Law Institute last week, and so you've just been spending a lot of time in front of the computer, listening to other lawyers talk at you. So we want to just start today by thinking about what is domestic violence, and it's a term that that sometimes people say family violence, sometimes people say intimate partner violence, gender-based violence. For the purposes of our discussion, we are going to use the term domestic violence because that's what's really defined in the law. And in Colorado, there's a couple of different definitions that you'll see in the laws in Colorado. We've put the statute here on the screen for the best interests of the child standard, because I think that's where a lot of you are going to be looking. In the handouts that Tony Ann will send out after the presentation, you'll see the definitions for the criminal statute and the domestic violence protection order statute. But I think it's really important to just kind of start with what is domestic violence. And it is important to know for your cases, what is domestic violence in the best interest statute. And what I find interesting about this definition is that it really focuses on an act or a threatened act of violence upon a person with whom that person has been in an intimate relationship. And so we don't use the term family violence because that's a lot more broad. Really, when we're talking about domestic violence in this presentation, we're talking about domestic violence between intimate partners. That doesn't necessarily mean there had to be a sexual relationship, but somehow they had to be involved in some kind of intimate relationship. So while this particular definition is important to understand, and it's important in really thinking about why it was included in the law itself. Why did the legislatures take the time to call out domestic violence and make sure that people are paying attention to it within the context of domestic relations? What we know is that domestic violence is happening at epidemic rates in this country. So we estimate that somewhere around 1 in 4 women and about 1 in 10 men are going to experience some kind of domestic violence in their lifetime. Because we know that so many more women experience domestic violence, we tend to use gender pronouns when we're presenting. So we'll use she for victim and he for perpetrator. But I want everyone to keep in mind that no matter which partner is the abuser in a relationship and which partner is the victim, what we're talking about today apply across the board, and it certainly also applies in same-sex relationships as well. So just keep that in mind as we're moving along. What I think is a more important definition is not necessarily related to the statute, and that's what we call the social definition of domestic violence, which is simply a pattern of behaviors used by one partner to maintain power and control over another partner in an intimate relationship. So maybe some of you have seen the power and control wheel. We use a little bit, I'm getting a thumbs up, thank you. The power and control wheel is great. It's a great tool to use. It was developed by survivors, for survivors to really understand how it's a pattern of behavior. It's not that single incident, right? It's not this act or threatened act of violence. It's a pattern of behaviors that's used over time to gain power and maintain control. We use sort of a beefed up version of the power and control wheel called the maze of force and control, because I think it gives you a better idea of how individual behaviors on part of the person using abusive behaviors, and how institutions work in tandem with one another.
I heard about it 1 minute ago.
To really make it very difficult for victims that are experiencing abuse to leave, to safely leave, and to stay away. Because what we know is that domestic violence really interferes with so many parts of a victim's daily life. Their access to resources, their freedom to manage their daily affairs, including finances. It's estimated that in domestic violence, in 99% of domestic violence cases, there's some form of financial abuse. That's huge. That means like right there at the top, financial abuse is in almost every domestic violence case. It impacts their immigration, their status, and their ability to gain status, education, ability to meet their daily needs, ability to get to work, ability to stay employed, their parenting, and then all kinds of freedom from unwanted intrusions into their life. So it really is something that impacts so many facets of a person's life. And so when we think about the very narrow statutory definitions of domestic violence, it really doesn't give folks an understanding of just the number of ways that domestic violence can impact a particular person's life. Jen, did you want to add anything to that?
No, I'm good.
Okay. One of the things I also love about the maze of coercive control, I'll just say before we move on to the next slide, is that I think about it's being used as sort of if you're at the center of that wheel, right, and you're trying to get out of an abusive relationship, that maze and even the name itself conjures this image of a person trying to navigate all of these individuals and systems in order to safely leave that relationship. I also love to think about it, and someone at a training once mentioned this to me, is it's also a map for service providers to be able to make their way in to assist that victim in getting the resources that they need to be safe, and for their families to be safe, and for them to be able to exit that relationship in a way that, one, keeps them safe, and two, helps them to be able to provide for themselves and their families. And so Jen's going to talk about way at the end, what are some community resources available, because we know that as a domestic relations attorney, we are just one small piece of a puzzle in helping survivors to gain to gain safety and keep safe in the long run. I just want to mention a couple of fatality risk or lethality risk factors. And we mention this because when you are working with a client who's experienced domestic violence, or even if you're working with someone who has used abusive behaviors in the relationship, separation is often the most dangerous time for a victim. So we get a lot of questions when we do more general trainings. Well, why don't they just leave? If they're being abused, why don't they just leave the relationship? Well, one, I hope that maze of coercive control gives you an idea of how difficult it actually can be to extricate oneself from that relationship. But also, when we ask that question, we're presuming that that person is going to be safer if they leave. 75% of domestic violence homicides occur after someone has chosen to leave that relationship. And if you think about domestic violence with that context of power and control, so it's someone trying to exercise power and control over their partner, if you leave, right, you are trying to get out of that person's control, and they're going to tighten the grip. They're going to actually escalate those controlling behaviors to get that person to stay and be under their control. And so we definitely see an escalation of violence when people choose to leave, even if they choose to use the legal system. And so we want you to be aware of some lethality risk factors to be on the watch for if you're working with someone who's experienced domestic violence, because a combination of these behaviors and the more of these behaviors that are exhibited, the more lethal a situation can be. We can't predict it with any kind of science, but this is just based on a lot of experience. When you get an increase in the number of these lethality risk factors, that means it's going to be particularly problematic for that person, which could potentially mean that they return to their abuser because they are afraid for their safety or the safety of their children, the safety of their animals, and the safety of their other family members. And so this is just something to keep in mind. And again, Jen's going to talk about other resources in the community at the end. This is when an advocate comes in handy to do some safety planning with that survivor, to be done sort of in tandem with some of the work being done in the courtroom. And so these are some lethality risk factors. And of course, as I mentioned, separation itself is a lethality risk factor. And I really do want to call attention to access to firearms as another lethality risk factor. And Jen's going to talk a little bit about some recent legislation that looks at particularly abuser access to firearms.
If you can go back just for a second, Amy, I do want to just highlight avoidance of consequences, because I think when we're in the midst of a domestic relations case, that is where we can really see this play out. And it's so important to make note when you've got someone who is violating court orders, who is continually using talking parents to do things other than talk about the child, or is violating a protection order, or is keeping the child an extra night and refusing to return them. All of those sorts of things are part of this avoidance of consequences piece here. And I too often have seen our domestic relations system downplay that, talk about it as, well, you know, this person was confused, or they're overwhelmed, or this is just so stressful and emotional for them. But it really is important. It really is a lethality risk factor. And so I just wanted to flag that.
Yeah.
Go ahead, Amy, thanks. So this is one of those things that we could probably spend an entire presentation talking about, and I'm just going to touch on, which is both the existence of these laws and the recent changes that happened. So abusers who are subject to criminal and civil protection orders that are based on domestic violence, or who've been sentenced for a crime involving domestic violence, are subject to restrictions on owning and possessing firearms and ammunition. That's been in place for a long time. Colorado codified it in statute in 2013. But this last legislative session, we added procedures. One of the biggest concerns we have had from an advocacy side for many years is the fact that we have these laws in place, but there's really no process for accountability. There's no process for ensuring that someone actually relinquishes their firearms. Now we have that, and we're still waiting to see how it plays out. It went into effect July 1st. The big thing to note is that this is going to add a hearing, particularly in civil protection order matters, which is what's relevant to our conversation today, 8 to 11 days after the permanent protection order is put in place. The court will set a review hearing to make sure not only that the affidavit showing that the person either does or doesn't have firearms is completed and submitted to the court, but that relinquishment has actually happened. And it gives the court the ability both to hold someone in contempt and to issue a warrant and a subpoena, or a search warrant, sorry, to go search the home if there is evidence of firearms. So, so this is just really important. Again, we could spend a lot of time on this, and I'm not going to, but I would recommend that you familiarize yourself with these new processes, because we are going to need to have our clients be prepared for this process looking a little bit different and providing different types of information to the court about firearms than what we've done in the past.
And I also think it's really, I'm sorry to interrupt, Jen, but like, you know, if you are doing domestic relations because of these laws in place, I mean, that's going to go also toward property. And so if there is a permanent protection order in place, that long-term, there's a long-term piece to the not being allowed to have weapons. And so that might actually have to be addressed in the property distribution.
Good point. Thanks, Amy. All right. Well, let's talk a little bit about how domestic violence impacts children. And the things that we often see are that our systems tend to minimize this, that lawyers tend to minimize this, judges tend to minimize the fact that domestic violence has an impact on children, whether it's through direct abuse of the child, abusing another person or animal in the home. And we know from research that a child witnessing threats to their primary caretaker, to the person they trust to keep them safe and to care for them, is creates the greatest risk of trauma for children. So where a parent is being abused, even if it's not in front of the child, that is absolutely having an impact. And harmful parenting, which we'll talk about a little bit more in this next slide. Lundy Bancroft is someone that we really turn to when we're talking about the impact of domestic violence on children. He has a book called The Batterer as Parent, and there's a second edition called The Batterer as Parent 2, which is just an update, which I highly recommend. It's a really fantastic resource if you're working in this field and you're representing survivors and their children in these cases. Abusers don't just do the things that were in the maze of course of control that Amy showed you with the adult victim. They also have similar behaviors that they use in their parenting of their children. And Lundy Bancroft breaks it down into these 5 categories. And again, we could do a whole presentation on the impact of domestic violence on children, maybe 2 of them, because it's a lot. But they are authoritarian in their parenting. It is very black and white. It is very my way or the highway when it comes to parenting. They are frequently irresponsible, neglectful, and or under-involved, and then blame that on the victim and expect the victim to be the person who is constantly picking up the pieces and making sure that everything gets done. So they're irresponsible and neglectful, but not necessarily oblivious, I would say, to what needs to be done. They're just not going to take responsibility.
Oh no.
They are self-centered, which is really what that's about. They're manipulative. Coercive control is manipulation, and they do it with children. As well as a guardian ad litem, and I saw a lot of this manipulation of children. It can be as blatant as take pictures when you're at mom's house of the dirty dishes in the sink and bring them back to me. I want to prove she's a bad mom, to things like, if you refuse to go to mom's this weekend, I'll take you to the zoo, kinds of stuff. So we see just a wide range of manipulation. We also see where they undermine the adult victim's parenting. And that's, adult victims setting boundaries or saying, no, you can't have that, or you can't do that. And the abusive parent saying, I'll let you do it. I'll take you to do that. I'll get you that thing. And it can simply be a disciplinary action where, mom is saying, you misbehaved, go to your room. And dad says, you don't have to go to your room. You don't need to listen to mom. She's dumb. And making those kinds of comments, calling her names, insulting her. All of those things undermine the victim's parenting and the victim as a parent. Both of those things happen. The thing that we flagged here that is just so important and so often helps abusers get away with it is that they perform so well under observation. The thing that is so hard for people to understand about those who commit domestic violence is that they have complete control over it. They don't have an anger management problem. This is not something where they just lose control. They know exactly what they're doing. They don't do it at work. They don't do it in public. They don't do it with the cashier at the grocery store. They do it at home, and they do it with the person they're in an intimate relationship with and with their children. When you are talking to this person, whether you are representing them or they are the opposing party, or when I was a CFI and a guardian ad litem, oh my gosh, the way that these folks were able to perform in front of me and just put on their absolute best act about their concern for their children and their concern for the other party. They are just really good at it. And it's so important to keep that in mind and to remember that just because the victim is describing all of these, what sound like loss of control kind of behaviors, doesn't mean you're ever going to see it. You may never, ever see it. The ones that you do see are that lethality risk goes up. Because as soon as they start to do that in court, in front of you, I have seen abusers in court just start to tell the judge exactly what they think and exactly what they're doing and think they're absolutely right. I think that's when things really start to escalate, and it can start to be even scarier. Amy,
Can I add, Jen? I think that's really important, that idea about the fact that they are very well controlled. It's not about losing control. It is about gaining control. And as you mentioned, they're very victim selective. But it's also, you know, sometimes your client, if they're the victim, may phrase it like, sometimes he just gets totally out of control, you know, that can key you into that he may have impulse control issues potentially, right? Likely not, likely that is just part of their behavior, but you know, in a very small number of cases, you know, maybe counseling or anger management could be appropriate, and so is offender management. So like, it's never usually one or the other. So you know, people think about, well, if someone is an abuser, they may have a mental health problem. Well, we know mental health does not cause domestic violence, because a lot of people with mental health problems do not abuse their partners. But it could be co-occurring, but then you need to look at both of those things. So don't just think that by treating one aspect of that person's behavior, you're going to keep all of the other stuff, or you're going to fix all of the other stuff. So just be really aware of that. Even in the way that your client might present the information to you, really be thinking, okay, what is this bigger picture?
Thanks, Amy. Let's go ahead to the next.
Sorry, having some slide issues.
Childhood exposure to domestic violence is a type of traumatic stress on children. And it is not unusual for children who have lived in an environment where there's been domestic violence, where they have been victims of domestic violence, to experience lifelong physical and mental health problems, such as anxiety, depression, and traumatic stress, difficulty with relationships with others, academic and employment failures, and trouble parenting. We see all the same things with children who have lived in a home with domestic violence as we see with other types of childhood trauma. It is not the seeing it. It's not the direct sort of witnessing of it that might involve law enforcement, that might involve child welfare. It is that ongoing sort of knowledge and understanding, I would say, that this is going on, and the way that it's impacting the child and the parenting that they're experiencing. We know from research that exposure to domestic violence causes difficulties with children starting in the womb, that a child who's exposed while mom is pregnant can have traumatic stress responses. And we see so many different ways that children are involved and are exposed. We see some kids who try to directly intervene to try to stop the abuse and protect one parent or the other. They may retreat and hide. Children may tell you about hiding in a closet or under a bed when they start to hear things escalate between their parents. They're likely to be witnessing the impact on a parent. You know, some of the difficulties that we see in representing clients in these cases is that victims have been so beat down that they're struggling to function. They're struggling to parent. They're struggling to kind of get it back together, so to speak, and regain control in their own lives. And children are seeing that, and they're being impacted by that. Some kids may seem to be unaware of what's going on, or they might tell you they're unaware of what's going on for a lot of different reasons. Maybe out of concern about getting someone in trouble. Maybe they don't want the abuser to go to jail or lose his job. All of the same concerns that we see our victims have in getting law enforcement involved can be true for kids. They're very aware at much younger ages than we often give them credit for. But some of what we want to look for in kids, and when we're representing adult victims, we want to ask some questions about these things because we are responsible for representing to the court what's in the child's best interest. That we want to look at whether the child's experiencing developmental issues or behavioral issues or emotional issues, cognitive issues, relationship or social issues. It's not uncommon to hear that the child's getting in fights at school. Health issues, certainly issues with things like potty training can be signs that there is something going on that we need to pay attention to. And then of course, if there are economic issues going on within the family that are being caused by the abuse, the financial abuse, as Amy mentioned, being one of the most common things in all of these cases, that's something we really want to notice as well. Amy?
Yeah. We're going to switch gears a little bit away from sort of impact on kiddos. Does anybody have any questions so far about what we've talked about before we move on? I just want to allow a moment to see if
we're
anybody has
okay.
questions.
Thank you.
Okay, great. So I mentioned earlier that separation itself is not always the safest option for someone. And so when we think about, why doesn't this person just leave that relationship? Well, there's a lot of safety concerns as well. But there's also not just physical safety concerns, but ongoing concerns around their emotional and psychological well-being. And so separation and ultimately divorce or APR don't necessarily solve the issue of domestic violence. And so oftentimes we see both pre-decree and post-decree that abusers really try to manipulate and use the legal system against the victim as one way of exercising that power and control. And so it might be filing repeated petitions or motions, not responding for a really long time and then jumping in sort of at the last minute. Sometimes appealing judges' orders without really a legal basis just to draw things out. And again, we see this happening during that initial pre-decree time and then also post-decree. Some people call this litigation abuse. And unfortunately, we're seeing it happen more and more. And in fact, we're seeing very, very protracted post-degree cases that go on just for years and years and years. And if you think about someone starting the process when maybe a kiddo is 18 months old, that's 16 years until that child ages out of the system, that this kind of thing can be going on. And so, that's really something to kind of pay attention to. And what's really difficult is that it's really hard to limit someone's right to file something in court. And we know that, right? There are some ways that attorneys can attempt to address both pre-decree and post-decree litigation abuse. And in some jurisdictions, some of these work better than others. But you can try to seek orders that restrict a person from filing a motion without first obtaining the court's permission, right? We do have rules around conferring with the other party, but this goes actually even one step beyond that. You could ask for orders on limits on the number or frequency of filings. Some states have actually considered legislation, and some have even passed legislation around this. Colorado is not there yet, but it's really something that, if nothing else, you can try to call the court's attention to is going on. But again, like we find that this is a really difficult situation because it is really difficult to limit that behavior in the court system that we have now. But I think it's just really important to be aware, and then to, and we're going to talk about this a little later on in the presentation, really try to craft separation agreements, orders, parenting plans, parenting time plans, in a way that really tries to limit the ability of one party to use litigation abuse to continue their ongoing reign of control after that divorce or APR are finalized.
I have an example of a case where I was the child and family investigator that to me was just really, really extreme. And of course, this is a case where neither party had an attorney, and it was 10 years post-decree. And there had been multiple motions filed by the abuser every single year for 10 years. And most of them were motions for contempt citation against the victim that said things like, she claimed the kids on her taxes when she wasn't supposed to. I want the solution from the court to be that I get full custody. So, you know, things that just aren't even consistent or relevant to each other, you know, but it's a means by which to try to get in front of the court and get the court to relitigate things that have already been addressed and already been considered, and to keep the victim responding, to keep the victim in contact, to just keep this control going. And that's really what all of this is about, is it's a means by which the abuser continues to keep the victim within his realm of control by using the court system to do it.
Yeah.
This is another topic, court-appointed professionals, that we could probably spend more than an hour and a half talking about, but we just wanted to touch on this. So in these cases, of course, there are 4 typical types of court-appointed professionals that we might see: CFIs, parenting coordinators, decision makers, and parental responsibility evaluators, or PREs. We at Project Safeguard run into just so much difficulty finding court-appointed professionals who really understand domestic violence and are really able to make recommendations that take the domestic violence into consideration. What seems to happen all too often is that each party's story, each party's evidence gets equal weight, and there isn't really analysis of the coercive control that is going on, of the domestic violence dynamics that are happening. And we end up with parenting recommendations that are, you know, are just going to continue the course of control, just going to lend themselves to that being continued. There is a minimal or no training requirement regarding domestic violence for these court-appointed professionals. You may all be familiar with the bill that passed this year, House Bill 21-1228, that adds some very limited training for court-appointed professionals, 6 hours total, I think, initially, and then 4 hours every several years. I should have re-looked at that again before we started today. But regardless, there isn't really any language that says who's going to provide that training. The categories are very broad. I have huge concerns about the ability of court-appointed professionals to obtain training that would meet this requirement that Amy and I would be horrified by. So this is an ongoing concern. Of course, training for judges is a concern as well. But I just wanted to flag this. I think court-appointed professionals, having been a CFI for a long time, can be really valuable in these cases. if you get someone who really understands domestic violence and is willing to make recommendations that address the domestic violence. And I think as attorneys, we need to be asking those questions. Not only what do you understand about domestic violence, but what does that mean to you in terms of the best interest of the child, and what does that look like for you in terms of making recommendations? Parenting coordinators, I'm not a fan of using them for domestic violence. There is a statute, and I just thought of it now, so it's not included in anything that we prepared. With regard to one parent objecting to the appointment of a parenting coordinator, I certainly would lean on that as much as possible. I just think when you've got one person who's using coercive control, the role of a parenting coordinator and even a decision maker, where they are in a position where they're supposed to listen to both parties and try to help them resolve problems. And I'm going to talk about mediation next. It really just, again, perpetuates the problem. And then we're talking about parties paying, thousands, if not tens of thousands of dollars for those services. And I'm seeing some questions popping up in the chat. So I'm going to stop for a second and take a look at those. Could you address whether you see DV when you have two parties who can't stop filing against each other? It keeps the parties engaged and the children are at the heart of the conflict. Thus, the mutual engagement is traumatic to the children. So, David, are you saying both parties are doing this, and that's the question?
Yes, that's what I'm saying.
Okay, thanks. So, what we always want to look at with domestic violence is what is the intent and what is the impact of what is happening. So, this could be a high conflict combative couple. And then we wouldn't call that domestic violence. Domestic violence is one person using coercive control over the other. But if we have one person who is doing these things for coercive control and the other is responding and trying to react and maybe level things out, we want to look at that. We really want to look at the intent of each of the parties and the impact on each of the parties to try to find whether there is a coercive control dynamic happening if one party is exerting that. I think if you've got two people who are high conflict and they're both filing, I think the best thing you can do is ask the court to try to address that. We have talked for years about trying to, and I think Amy mentioned this, address litigation abuse in statute. Other states have done it with varying degrees of success and in different ways. But that is certainly something that we need to work on. And then I see the question about specific training for CFIs. So,
can I add something really quickly, Jen?
yeah, go ahead.
Because I think it's a great question. I always think about domestic relations itself can be pretty contentious when domestic violence is not even a part of it, right? And then you throw in domestic violence and we're taking it to a whole different kind of level. And I almost even mentioned when I was talking about the litigation abuse, a case that we're currently in the middle of, where we are having to file so much more than we would normally file. And it is because the other party simply will not follow court's orders. And it is constantly about that. And so, and I hate doing it. Like, I don't like to be that attorney. I don't like to be in the court all the time. I don't want to be the one seen as contentious or problematic or using the legal system. Yet at the same time, I have to zealously represent my client, and there are some times where that is absolutely possible. So, so I just wanted to say that like that is very difficult, and sometimes you have to be really either reactive or proactive in order to keep someone safe or keep a family safe. But that, I think Jen's conversation around the intent and impact is really important. And if you look back at behaviors throughout the marriage, that's a really easy way to try to get that assessment. And then that carries over into that litigation piece. So I just wanted to add on to that.
Thanks, ladies. And there are two questions, Jen, in the chat. One is, where would you get CFI training? And I'll let you answer that one, and you can either read or go on to the other question after.
Thanks, Tony Ann. So there are lots of trainings available through the domestic violence victim services providers around the state of Colorado. And our statewide domestic violence coalition is called Violence Free Colorado. They have a variety of trainings that they offer. There is an annual conference, the Colorado Advocacy and Action Conference, which when it's in person is in Vail in June, is a fantastic opportunity. And then there are some wonderful resources at the national level. One is the ABA Commission on Domestic and Sexual Violence, which offers webinars frequently on these topics. And there's the Battered Women's Justice Project that also offers lots of really great webinars on a variety of topics that are related to all of the things that we're talking about today. You don't have to be an ABA member to be able to just join the commission's listserv. So that's also a great resource. What am I forgetting, Amy?
I think those really rise to the top. And I think really, you know, any training that really addresses what are called the dynamics of domestic violence, that's what you're really looking for, is to really understand those dynamics. Because first you really have to be able to identify it before you can address it, and you have to identify it correctly. Someone just in the box mentioned Battered Women's Justice Project. They also do a lot of great trainings for lawyers.
And I see Sarah Bush has said she's currently taking a 5-part GAL domestic violence webinar from them. That has been amazing.
Great, good. Oh, I'm so glad to hear that. Yeah, they do really great work.
They also on their website have some fantastic tools. They have a whole custody page. That's an understatement. They have so many resources. There are worksheets you can access. There are just all sorts of materials on Battered Women's Justice Project's website that are fantastic tools for doing this sort of work.
And then I'll also put the acronym there, the National Council for Juvenile and Family Court Judges. Did you mention that before?
I didn't, but they are.
Yeah. That's also, even though they say it's for judges, they have a lot of great trainings on there as well, and host them as well.
Okay, so I had a chance to read Anthony Zarsky's question, which was about law enforcement not enforcing protection orders, is how I read it. We see this all the time. And one of the things that we really try to do at Project Safeguard, and we don't do it that often, but we pay real close attention to this. A lot of times violations of the protection order are not crimes. There are a lot of things that someone could do to violate the protection order that, like, you know, talking parents, it certainly is a violation of the protection order and it should be charged, but law enforcement seems to be reluctant to charge those things. And so for us as a nonprofit that provides free legal services, you know, we're in a position where we can file contempt motions, and we will do that if we have to. If law enforcement isn't going to respond, it isn't going to enforce the protection order. The other thing I would suggest is to contact the Rocky Mountain Victim Law Center. They're a nonprofit that works predominantly in the criminal system, and their focus is victim rights and enforcement on behalf of victims. So this would be something that they may be able to help with. They may be able to contact the law enforcement agency that isn't responding and advocate on behalf of that victim. But I'm not surprised to hear you're seeing that. We certainly see it quite a bit.
Yeah.
Okay. Oh, mediation. Yes. Got so wrapped up in the questions, I skipped a slide. So mediation, as you know, is ordered in every case. And in many of our cases, although this statute, 1322-311, says that the court shall not refer the case to mediation when one of the parties claims they've been the victim of physical or psychological abuse by the other party, and there is a JDF, and I cited the JDF in one of your handouts, it's not here, that's a motion to be exempted from mediation. We often have survivors who want to do mediation. They're really hopeful that they can settle some things through mediation. So we really look for mediators who have knowledge of domestic violence and who will do shuttle mediation. Of course, we've been doing mediation remotely for 1.5 years now, so that has changed the dynamics a bit as well. But we're still doing shuttle mediation. We're still not having our client have to see their abuser and try to be face-to-face and try to resolve anything with someone who uses coercive control. It is just the antithesis of what makes mediation worthwhile is coercive control. So when it's appropriate, we will file a motion to have our client be exempted from mediation, but we also find that courts don't always grant those. So we have some mediators we really like and that we work with that we think really understand domestic violence and have had success with. And like I said, shuttle mediation is the key. Doing court remotely has in many ways been really great for our clients because they don't have to be in the same room with their abuser. And as one of our attorneys likes to advise clients, you can put a Post-it over the abuser's face and not even have to see him. And that's been great. But at the same time, I have concerns about some of the nonverbal body language and some of the credibility assessments that the judges make when they're not seeing the victim react to the abuser in person and things like that. So I am happy to, if you want to email me, I'm happy to give you the names of the mediators we use. I'm not going to say people's names to a group of 94 participants today on this presentation, but Amy, do you want to add anything about mediation?
Nope, I think that's great. I guess I would add, the only thing I would add is it is really important to prepare your client for mediation. If they have experienced domestic violence, let them know what they can expect. Let them know that you've asked for it to be shuttled, that it will be, so beyond just preparing them for mediation in the way that you would normally, talk about the other levels of protection, for lack of a better word, that are going to be in place to make the process better for them, because I think that relieves a lot of anxiety going in, and it might not be something that you think to talk with them about.
That's a great point.
My thing is moving really slow, so I keep thinking I've advanced it, and then I don't think I have, and then it turns out actually I have. So I apologize for the back and forth. So, okay, so we've talked a little bit about what is domestic violence, why it's important to understand it, some of the process leading up to this part, which is what are some implications of domestic violence for parenting plans and separation agreements. So how do we think about how to limit future abuse in the future, level the playing field, keep survivors and their families safe, and hold perpetrators accountable, okay? Because when there is not accountability, that kind of behavior will continue. And even if for some reason it does not continue with this particular victim, it likely will continue in the future and in other families and potentially with other children. So what can we do in that domestic relations, in the domestic relations world? So if you think about what kinds of interventions and treatment might be needed, really consider that they should only be provided by providers with either some sort of credentialing or demonstrated expertise in domestic violence, okay? So a lot of mental health professionals and court-appointed professionals do not have this expertise. So find out who does and address it that way. Speaking of mental health, marriage counseling is often absolutely counter to holding perpetrators accountable and creating safety for victims. So we actually find that marriage counseling is counterindicated in cases of domestic violence. Again, that might not necessarily be something that you're dealing with in the final plans, right? But that could be as part of the process leading up to it. So keep that in mind. Really think about, where is supervised parenting time appropriate? And what about supervised visitation exchanges? What is appropriate and where? So supervised visitation exchange locations can be out of the way, they can be expensive, but they might not be the only ones that are locations that are available. We find that public places that we know have cameras are good, and backup plan, because something will always happen. So if you try to do visitation or parenting time exchanges at school, so parent one picks up child at Wednesdays after school. Okay, well, what happens when there's a snow day? What happens with COVID? What happens when it's summertime? Obviously, most plans have some sort of variations for summertime planning, but then what's the supervised visitation exchange site in the summertime? So again, like, don't just be thinking about one, be thinking about the backup to the backup to the backup. And basically thinking about, how do we limit the abuser's access to the victim, and when appropriate, how do we limit their access to the children? Let's see, how about decision making? So we know that 14-10-124, like 4A, 2A, I'm going to expect you all to remember that. It's against the best interest of the child to allocate mutual decision making over the objection of one party, unless the court finds there's credible evidence of the ability of the parties to make decisions cooperatively. Well, if you think about domestic violence in the context of power and control, if one person's goal with their behavior is to exercise power and control, that means they don't work cooperatively, right? So how do you make those arguments against joint decision making? And really, again, it's really important to be specific. So I'm just trying to think about a couple of other things. Oh, parenting programs. So obviously in these cases, most parents are having to undergo the basic court-appointed parenting classes. There are parenting classes out there that are specifically designed for people who use abusive and controlling behaviors. So one that rises to the top is Caring Dads. And we do have a lot of providers of Caring Dads in the Denver metro area. So perhaps and it's for caring moms as well. It's just called Caring Dads. But it really specifically looks at people who are not clients, who are not child-centered, and helps them understand what child-centered parenting looks like. So that might be a hurdle that one parent has to get over in order to have more or unsupervised parenting time with a child. You can consider domestic violence offender treatment. This is not mental health treatment, to be clear. This is specifically designed, again, for people that are using controlling behaviors. It used to be that they would have to be court ordered through a criminal case to be involved in offender management. That's not the case anymore. There's not a lot of providers that do this this kind of non-criminally court-ordered offender management, but we're lucky that in the Denver area that there are more treatment providers that do that. And so just be thinking about, how can you set up parenting plans that really look at that history of coercive and controlling behaviors in the relationship, and how can you address that within the parenting plans? And again, this is not meant to punish someone, right? It's not meant to punish an abuser, it is meant to hold them accountable and to minimize that kind of behavior in the future, because one, we know that it impacts kids, right? And it becomes a continued safety issue for potentially your client as well. Also, be thinking about, overnight visitations and what does that look like, and what guardrails do we put around there? And then you also have to consider, what happens when one parent decides to relocate? And if before there were no overnights allowed, what is that going to look like for the future? And really thinking about how do you safety plan with your client, or consider those safety issues that might come up, and how might you provide for that in any kind of in relocation and maybe a modification. Also think about even talking parents. When you're thinking about parenting plans and you're using talking parents, what are some guardrails that you can put around talking parents so that they are only allowed to speak specifically about the children's immediate, health and safety needs? Again, like that's getting really specific, but you can be specific and try to be so that the boundaries are really clear. Because otherwise, what we do know about people who use coercive and controlling behaviors is that they will push every boundary to see how far they can get. Let's see. Any other implications for parenting plans, Jen, you wanted to specifically speak about?
There was something that I meant to mention earlier that you alluded to a little bit, Amy, around mental health and psychological concerns.
Yeah.
Oftentimes when we use court-appointed professionals, they want to do psychological testing, particularly if we're using a PRE, of course, in these cases. And there is fantastic research on this topic by a researcher named Nancy Erickson that really speaks to the fact that this is not a mental health issue. And often what happens when psychological testing is done is we find that maybe the abuser has nothing that shows up as a mental health concern, or maybe he shows up as mildly narcissistic, and the victim will show up as having borderline personality disorder or being bipolar or something like that. And it's not accurate. We know that most psychological testing does not accurately assess for post-traumatic stress disorder or for traumatic stress responses at all. And it certainly does not test for committing domestic violence. That just isn't a mental health disorder. So I just wanted to flag that as being really important to be considering when we're talking about what are we going to request at the court order, what do we need to consider in terms of parenting plans. Amy, I'm sorry if I was distracted if you mentioned the address confidentiality program.
No.
One of the things that can be really valuable when we're talking about a parenting plan, and this is really about protecting the victim parent's well-being, and while still allowing for exchanges, allowing there to be appropriate parenting with the abusive parent, is getting our victim client enrolled in the address confidentiality program. That is a state program that allows someone who's been a victim to sign up and use an alternate address. It's a fairly generic address where all of the mail will go. It can be used for a variety of other purposes. And then it gets sent from the address confidentiality program office to the victim at their home. So that getting signed up for that is actually very simple. It's something that our advocates do. It's something that most victim advocates do. And I will, again, talk about community-based programs towards the end of our presentation. But I am going to put the link for the address confidentiality program here in the chat so that you all have that information as well.
Yeah. I was looking in the chat while you were speaking, Jen, and someone brought up the parental alienation and accusations or allegations of parental alienation, specifically, dad filing repeated claims against mom that she's alienating the kids, even though dad might be the one in that particular case using coercive control. And that's something that we see a lot. So first, for those of you who might not know, that parental alienation syndrome is completely debunked. It is not a thing, and yet it is definitely something that particularly I have found attorneys that represent abusers are more than happy to try to bring in. So most judges, I think at this point, understand that that's no longer a syndrome, a thing, and yet the term alienation does come up quite a bit, right? Parental alienation. And Joan Meyer, and her name is M-E-I-E-R, Joan Meyer has done just a ton of research in the issue of custody, domestic violence, and specifically the impact on moms that are experiencing domestic violence and that are trying to seek assistance through domestic relation courts. And she finds that that the empirical research indicates that mother's abuse, especially allegations of child abuse, right? Because oftentimes a parent who alleges domestic violence also may allege child abuse, that these allegations in custody cases are far more often than not rejected and actually increase mothers' chances of losing custody. So the research actually indicates, and you can read her research, she's combed through cases in a number of different states, that when someone brings up allegations, when a victim brings up allegations of domestic violence and specifically alleges also that their children are being abused, that actually puts them in a very precarious position legally, and oftentimes they end up losing custody. And so I really encourage you all to take a look further at that research and think about, but that is something that we see a lot. And so again, that goes back to, one, trying to find a CFI who understands these issues and is going to create a report that really assesses the history of abuse in the relationship, looking at intent, right, of the abuser, impact on the victim and on the rest of the family. And then going beyond that, I thought it was interesting in listening to, I want to say Judge Lung spoke at the Family Law Institute last week and said he does not just sign off on CFI reports, that he expects attorneys to, that if they don't agree, or even when they do, that they want evidence from the attorney as well to support the CFI finding or not. And so I know that not all judges are as critical, that some really just use the CFI report as a way to come up with their own ruling, but really be conscientious about how those allegations of alienation are being addressed, because what we know is that is a victim's attempt at trying to keep their children safe while also being able to safely to leave that relationship. Because if there is a chance that their children are going to be unsafe if they leave an abusive relationship, that is very good incentive for them to stay in the abusive relationship. And the abuser knows that. Let's see, I did it again. So really just think about how is it that we can get orders from judges that best protect victims and also hold offenders accountable, so that behavior doesn't continue, and they're not, and that especially children are not continued to be impacted long after this particular case is done. I'm going to take a minute and look through the comments. Jen, do you have any? Did you notice any in there that you want to address before we turn to the next topic?
I'm frantically trying to keep up.
I love all the activity though.
Right, I was trying to find the link for Joan Meyer's article.
There was a question about whether the proposal published in 2014 by Meyer, whether there was results for the study, where you could find that.
There was a full paper published, and I'm trying to find the link.
Recently.
I have the paper itself, but I'm trying to.
I was gonna say, it's in my email somewhere, so if we don't find it before then, we can find it afterwards. Tony Ann, did you see other questions that were coming up? I'm just trying to continue to scroll through.
All of them. There wasn't one earlier about mediation.
I'm
with
just seeing
respect
that.
to- Yeah, if you turn up for mediation, ask for shuttle, and the mediator doesn't do that, can you walk away?
I mean, I would say, so luckily I've never had that happen where the mediator did not take that very seriously and do that. I would say I would address it in the moment and see if there's another room that you can do. And if not, see about, rescheduling, but not being charged. I mean, if you speak with them ahead of time and have that conversation, again, I have not yet found a mediator that hasn't been willing to do the shuttled mediation. So I haven't been faced with that particular instance. So I don't know. Jen, have you had that happen before?
No, I haven't, but I wouldn't be surprised that it does.
Yeah, right.
Yeah. It is one of the
Okay.
advantages, I think, of doing remote mediation is that it does lessen the concerns there to a certain extent.
Okay, Joan. Okay, so it looks like most of these questions have been answered. Okay.
I think there was one more. From Diane, when a parent, usually mom is the victim of DV and dad uses coercive control with the kids and has been abusive, dad files repeated motions claiming alienation. Yeah, I think that's what we're addressing actually, so.
And Amber, it looks like I see some studies that you say contradicts them. Joan Meyer gets quite a bit of resistance. That is for sure. I don't know if I've read those particular ones, but if I'll definitely take a look.
And I know there is a lot of research from Dr. Harmon and folks have often heard from her. I will tell you that her research is just not in line with our beliefs around domestic violence and parental alienation.
Yeah, and I think it is really. I mean, I think why I like Joan Meyer so much is also looking at her secondary sources. So I always try to do that with a lot of the research, especially around this, that I find. Like, for instance, people used to be really big on like the conflict tactics scale and you have to use that when you're determining where, like, who's the primary aggressor and stuff. And then if you look at the conflict tactics scale, there's nothing about self-defense, and there's like this really weird way that they rate violence and stuff. And then you're like, oh, okay, well, it's really hard then to like be on board with that article when it's using a scale that like actually doesn't really represent what domestic violence looks like, because it's often treated as just like any other crime. But again, that intent and impact is very different than in other crimes. So anyway, I'll be anxious to take a look at those. So thank you for sharing them, just so that I could be aware of that.
I think the conclusion I'm coming to with Joan Meyer's paper is that it is not just posted online, that it's probably protected. So we can certainly share that with Tony Ann to send it to participants.
Yeah, and I think what's important too is it's also peer reviewed. And again, I don't know enough about these other ones to know, but again, I'm happy to take a look. And again, that not in line with meaning would be, again, in line with our understanding around domestic violence as a pattern of behaviors that's used to gain power and maintain control in intimate relationships. So not focusing on single acts of physical violence. Oftentimes domestic violence is defined as that. And while that might be helpful in a criminal context, that's not helpful in the larger context that we've been talking about. And so sometimes that's, when we say in line, that's what we mean as far as like a definition. And that's why we're very, clear to say like that is more of a social definition, but it gives us a better understanding of like who is the source of risk in a relationship, right? And in the context of children, for instance, where are the sources of resiliency, right? So we can look at discrete incidences of physical violence, but again, only as part of that larger context, right? And that's what makes domestic violence different than a lot of other, I'm going to say quote unquote crimes, but really what I'm talking about is behavior, because so much of domestic violence does not even rise to the level of criminal behavior. Yeah, so I hope that answered some folks' questions out there.
And the issue of parental alienation and our disagreements with Dr. Harmon. So we look at acts of alienating children from their parents as domestic violence. And it can look a couple of different ways. It probably can look 100 different ways, but predominantly what we see is we see the abuser actively alienating the child from the victim. We see the child being alienated from the abuser because of the abuser's act, and the abuser calling that parental alienation. And what Joan Meyer's research really showed is that when a victim alleges that there's been domestic violence and the abuser responds by saying, she's alienating the children from me, courts are more likely to give credit to the allegations of parental alienation than they are to the reports of domestic violence, and they fail to see that the parental alienation is a part of the domestic violence. And I think that's really where we see this differently than Dr. Harmon, is that she sees parental alienation as a standalone thing, and we see it as a tactic of domestic violence in this example. Certainly, we have all heard stories that involve children alienated from their parents that do not involve domestic violence. That is not what we're talking about at all today.
That was a good clarification, Jen, thanks. Okay.
Go ahead, Amy.
No, I was gonna move on to the next slide, but again, my computer likes to move 2 slides down.
So we wanted to just wrap up today and talk a little bit about community-based resources that can support your client. And that doesn't just mean Project Safeguard. There are agencies all over the state, and you've got 2 handouts. You will get 2 handouts about these programs. One handout is a list of all of the community-based programs that are similar to Project Safeguard that provide some sort of legal assistance. That could be legal advocacy, that could mean attorney representation, but it lists those programs and what kinds of services they provide statewide. On the other handout that has all of the statutes, there's a link to Violence Free Colorado's webpage. They have a specific page where you can look at the victim services programs by county around the state that provide services. And then of course you can link to their website and you can see what services those organizations provide. But one of the things that is often very confusing for folks who don't work in our world is that there are 2 types of victim advocates: system-based and community-based. System-based are going to be folks who work at the DA's office, who work for the police department. In some cases, they're going to work for a nonprofit that contracts with the police department or the DA's office. In some of our rural communities, that's the case. System-based victim advocates do not have any kind of confidentiality with regard to their communication with victims. They're there to help implement the Victim Rights Act, provide information to victims about the VRA, about what their rights are, about how the process works, but they're also there to prosecute the crime. So whatever a victim shares with law enforcement advocates or with the DA's advocate or other prosecutors' advocate is going to get passed along to the prosecutor. There is no ability for that person to keep anything confidential. On the community-based side, that's going to be nonprofits like us, like safe houses and shelters around the state, other small organizations, some of them larger, like Family Tree is one of the largest ones, that are nonprofits with victim advocates that qualify to keep everything confidential under both state statute and federal law. So at Project Safeguard, all of our advocates have more confidentiality than is required under HIPAA. It is very, very strict. So it allows us to work with our clients on whatever they want. If they are trying to decide whether to cooperate with law enforcement, if they're trying to decide what to share with law enforcement, we can have all of those conversations and we can talk about that with them without sharing any of that information with law enforcement, unlike a victim advocate in law enforcement. Programs like Project Safeguard and the others offer everything from shelter to counseling to support groups to advocacy services. Our legal advocates can help folks with their paperwork to file a protection order. We have our we are all address confidentiality program certified. One of the things that allows our advocates to do, in addition to sign people up for the address confidentiality program, is it allows them to write letters that allow survivors to break their leases. So if you're working with someone who is either living with their abuser or living somewhere where they want to move so that they can be in somewhere safe, that's something we can help with. That's something that actually our advocates can help with. Lawyers can't write those letters, but advocates who are part of the address confidentiality program can. Amy, what am I missing in this regard?
I think the only thing I would say is oftentimes a victim, if they're in the criminal, if they've been through the criminal or in any kind of the criminal world, likely they've been in touch with a victim rights advocate, and yet they may not have gotten in touch with a community-based advocate. That those sometimes are made available. The information about those community-based advocates are made available, sometimes not. And so I'm just hoping that everyone here today is, hears this and knows that that is someone that they can refer them to, because most of the time when victims come to DR attorneys and want to get a divorce or need an APR or something like that, they're dealing with so many other things that just is not really in the purview of an attorney to help them with. And so this is a really nice alternative than saying like, ugh, I don't know, and I really can't help you with that, sorry, right? It's like, wow, you know what? I'm not sure, but I'm gonna get you connected to an advocate at Safe House Denver or Rosandom Center or Family Tree, because I feel like maybe this is something they can help you with a little bit, right? And so just knowing that there's people out there that you can get your clients in touch with, because once again, as we mentioned in the beginning, domestic violence impacts so much of a person's daily life. And so it's really difficult for them to be able to focus on a legal case if they're about to be evicted, or if they have finally found a place to move, but they don't have anybody to help them move their stuff, or if they need help getting their child's help getting their child to school one day, or if they need childcare for when they have a court date. Those are the things that are more difficult for attorneys to help with, that advocates can do, that make attorneys' lives easier, right? Meaning that they make it so that their client can be more present for that legal case. So really, these are resources that help you because they help your client.
There are a couple of questions in the chat I want to respond to, and Tia is asking about a PRE who's insisting on speaking to 2 individuals at Project Safeguard, and that Project Safeguard is refusing. How can we prevent this from being reflected negatively on the client victim? I have so much to say about this. So first of all, federal law requires that we only release information if a client has signed a release willingly or voluntarily, and fully informed of what they are releasing, and then it has to be time limited. So if our advocate is being contacted directly, they can't provide any information. What would have to happen for us to release any information at all would be for the client to contact our advocate, sign a release with our advocate after a conversation confirming that the client is asking for this, that it is voluntary for them to be signing this release. And then we're going to release as little information as possible. And that's also part of what we have to do is limit what we release. This is always an issue I hear about every time I do a presentation with lawyers is how come victim advocacy agencies won't give us information? That's why. It's got to come from the client. So I would say, Tia, in this case, you can explain that. The fact that, you know, this has to go through that process. And if the client is being told they have to do this, that's not going to be voluntary from our advocate's perspective. And our advocate is going to probably decline to do that.
Thanks, Jennifer.
Yeah, and then with regard to non-English speakers, we will serve anyone regardless of their primary language. We have a number of Spanish speakers on staff, and we use interpreters, we use language line, we will provide services, and all DV programs will do that. It isn't just us. That is something that we are also required to do, is to be able to provide that service. As to litigation abuse being zealous representation, no offense to anyone on this call, but more often than not, what we see is that abusers hire attorneys who are much like themselves. And so, bless Amy, who does all of our family law litigation at Project Safeguard, for dealing with some very difficult opposing attorneys. It's really hard work. We also deal with some really great ones. So I think that's the hard thing, is that if you are on the opposing side of that and it's an attorney filing those things, trying to get the court to limit that is a lot more difficult.
Yeah, I know. I just saw Gregory's, text and was like, yes, I have no answer there for you, Gregory, but I stand in solidarity with you. Over time, relationship building, I think judges talk and hopefully they start to get it, and yeah, I think it is definitely the other attorneys are the hardest part of my job. And I feel like and that's probably the case for all DR attorneys, not just in the context of domestic violence, right? Because some are just really difficult and others are awesome. And yeah, I wish we had better answers to that question, but if anybody ever thinks of something, let's all share it, because that certainly happens. That looking, they seek out the bulldog, which again, like Family Law Institute, we were just talking about that, right? And unfortunately, I worry that some of those attorneys aren't the ones attending those CLEs,
Well, Jennifer and Amy, thank you so much. I want to be, honorable to your time and everyone's here. So we so much appreciate you coming on and helping us with these. I will take notes of all the links in the chat box, and I will also make sure that I send the materials on. So thank you again. Thank you everyone for joining us, but thank you so much for your time today. And we will record this and put it up on our website in a couple of weeks as well. So thanks everyone.
Thank you, everyone.
Thanks.
For having us, Tony Ann. Bye.